Good evening. Very good evening. I'm so sorry. There was some technical glitch. I think. Perfectly all right.
So I'll give a short introduction of ma'am. So we are here with Mrs. Shantani Bakshi. She has completed her graduation from the University of Calcutta and has been the first rank holder there. She was facilitated by the Governor of West Bengal for being the first rank holder. She pursued her master's in constitutional law from National Law University, Odisha. She is currently pursuing her PhD from NUJS, which is located in Kolkata, West Bengal, in the field of constitutional law. She has worked for the Center for Regulatory Studies, Governance and Public Policy as a researcher. She has also worked with the School of Legal Studies, CMR University, Bangalore, as an assistant professor. Currently, she is working as an assistant professor at National Law University, Jodhpur. She is a professor of constitutional law at nlujodhpur. So, ma'am, we are glad that you're here with us today. So,
Thank you.
Start with the question and answers right away?
Absolutely. Absolutely.
Okay. So, the first question which is asked by one of the students is Article 21 of the Constitution reads as no person shall be deprived of his life or personal liberty except according to a procedure established by the law. Why was such a provision adopted at the very first place?
See, with respect to Article 21 of the Constitution, as you have just mentioned, you have talked about a few important keywords. You have highlighted a few keywords. First among them would be life and liberty. Let's take them as a collective whole. And the second one would be procedure established by law. Now, life and liberty, we understand that life and liberty or equality, these constitute some of the most important objectives with which the Constitution of India was framed, and particularly the chapter on fundamental rights, because we need to understand that the concept of fundamental rights was not incorporated all of a sudden. It was a long process. If you talk about the starting point, let's say if we talk about the Constitution of India Bill, which is, though we do not have adequate evidence to justify that it was drafted by Bal Gangadhar Tilak, but it is called Tilak's bill as well. Thereafter, you have another bill called the Commonwealth Bill, which was created by Annie Besant, Mrs. Annie Besant. Thereafter, several resolutions passed by the Indian National Congress and the Karachi resolution particularly. Before that, the Motilal Nehru Committee report. Thereafter, the Sapru Committee report. All of them collectively, they have institutionalized the idea that we need a set of fundamental rights. Now, what kind of fundamental rights do we need? That became a major question. Now, not everything that was demanded could be accommodated within the ambit of Part 3 of the Constitution. But when we look at the document, when we see the Constitution of India and the Fundamental Rights chapter, we see some of the basic rights that were demanded. Predominantly, if you look at the preamble to the Constitution of India, you will see that there are several ideas like liberty, equality, fraternity. These are some of the most significant things that we wanted to protect ourselves, protect them from being invaded, because from the past, let's say the 200 years of British tyranny had made us realize or had created this consciousness amongst us that we need to protect our fundamental rights. So as far as Article 21 is concerned, if you see Article 21, it protects life and liberty, which is absolutely basic, because until and unless you can protect the life and liberty of the people of the country, it doesn't make sense to have a constitution at the first place. And the second part, with regard to the second part, that is procedure established by law, you will see that when we look at, let's say, the words procedure established by law, we have referred to the Constitution of Japan. to have this particular phrase, brought into the Constitution of India. But in the process, you have to understand that there was another interesting way of looking at it. Initially, the idea was that we will adopt something which was pretty much similar to that of the American Constitution, and which is called the due process of law. Now, the question is, why didn't we go for something called due process of law, and why did we go for something that is called procedure established by law? Now, we have to understand that one of the chief architects of the Constitution of India, who was B.N. Rao. So I'm sure all of our friends who have joined today, they are aware of the contribution of Dr. B.N. Rao to the framing of the Constitution. He was the constitutional advisor. So B.N. Rao, he had met Justice Felix Frankfurter. So he was a judge of the Supreme Court of US, and he had made an advice, a small piece of advice he had delivered to B.N. Rao, and he said that, see, I would suggest that you don't go for something like a due process model, because due process is something that is followed in the American Constitution. Because if you see the 5th and the 14th constitutional amendments in US, you will get an idea that they have used the expression due process of law. That means no person shall be deprived of his life, liberty, property, except according to the due process of law. But what is due process is something that has to be determined. It is something that has to be identified. Now, what was the problem, or what was the exact problem with the due process model? Now, if you look at the due process model, I'm reminded of a very important judgment by the US Supreme Court, which is called the Lochner case, or Lochner versus New York. Now, if you look at this Lochner era, the experiences of which made us avoid a due process model and go for a model that would actually, be in tune with the Japanese Constitution. It was like, when you sit and define what is due, we generally leave it to the hands of the unelected judges who will define or who will identify what is the due course of the law. Now, if I tell you that I have the liberty to take away or deprive you of your liberty, it's only a law, and the law need not only be a positive law or a law that is coming from a political authority, but the law also must meet the requirements of natural law, of natural justice, which is the most important factor here. But when we look at procedure established by law, it is something which is much more positivist in its outlook. That means if there is a law, irrespective of the fact that the law is a moral law or an immoral law, a just law or an unjust law, it doesn't make any difference. If it is a law, as long as there is a law, the law is capable of taking away your life and liberty. But the problem arose during Lochner era, where the Supreme Court started striking down all the legislations that were being, formulated by the government, and it was using, it had become a very activist kind of a court, and it was striking down every single law that was coming up during that particular period, especially labor laws. So they realized the importance of the fact that keeping it as due process. So due process means what? We don't know what is the law. It is the due process of law. So the moment what you need to do is you need to identify and lay down a process that the law practically endorses. But rather, if you leave it in the hands of the unelected judges to define what is the due course, that is something that was problematic. So they said that no, we will not have something of the due process. So it was considered as, as a negative model that was rejected by the Constituent Assembly. And then they went for the Japanese model, that is the procedure established by law. But when they faced the problem for the first time in the case of A.K. Gopalan versus State of Madras, that you must have heard about, in A.K. Gopalan, the court actually went for a literal interpretation of this particular phrase, that is procedure established by law. And they said that even if the preventive detention law does not meet the criteria of, let's say, justness and fairness, but at least there is a law in place. There is a law in place, and that law is capable of depriving you of your liberty, not somebody else's definition of what is a right law and what is a wrong law. As long as there is a parliament, the parliament has made a law, the law will be able to take away your life and liberty. Of course, here, what was the problem, or what was the question was with regard to the preventive detention laws. So gradually, if you see, as and when things started proceeding, we are reminded, of course, after this judgment, we see the cases of R.C. Cooper, we see the cases of the most landmark judgment of all would be the case of Maneka Gandhi versus Union of India. So Maneka Gandhi versus Union of India gradually led, though we had clearly identified that we don't want something called a due process model, right, on the floor of the Constituent Assembly. But later on, as and when we proceeded, we realized that we cannot do away with the requirement of natural law. And hence, we invited something called procedural due process. Procedural due process means the procedure should conform to the requirements of natural law and natural justice. It should be a fair procedure. If you want to take away somebody's life and liberty, it should be by way of a fair procedure. And then gradually, as and when times, went by, you will see, cases like Sunil Batra, or like, for example, even the recent years, we see judgments like, let's say, Navteej Singh Johar, or let's say Joseph Shine, Section 497, Section 377, all of them are reflective of the idea that today it's not only the procedural due process, but also the idea of, let's say, substantive due process that has been incorporated into the constitutional law framework in India. So merely because of the fact that we have rejected it outright, it was because of the fear that we don't want an activist judge to replace what a representative institution like the parliament is saying. If the parliament says that, yes, this is how you can deprive somebody of his liberty, then that is the only way that should be followed. That was something in the mind of the constitution makers. But gradually things started changing. Archaic laws like that of 497, 377, we cannot allow those laws to continue in a country which is standing at the threshold of the 21st century. So we had to do away with them, and hence we are dealing with substantive due process. We are dealing with substantive provisions and determining whether they should stay in the statute book or not. They are constitutionally fit or not, right? So these are different factors that, that's the development all about that we need to take note of at the time when we look at Article 21 of the Constitution. Yes.
Thank you so much, ma'am. And we'll go to the second question, which is, what are the various rights that have been accommodated within the ambit of Article 21 of the Constitution?
I think the question should have been the other way around. It should have been something like, what are the rights that have not been accommodated into Article 21 of the Constitution? Because, you know what? Article 21 talks about life. And life would entail anything and everything that goes along with it. So, of course, this is not the statement that I am making, but this is a statement that has been made right from the time the Constitution was in force, and we realized how important and how significant life is. And if you read cases like Francis Corelli, or let's say if you read cases like, Olga Tellis, all of them have one single thing in common. And they say that life is not confined to mere animal existence. Merely if you live like an animal, that wouldn't suffice, because the Constitution at the first place was created to respect individual autonomy, to respect individual dignity, human dignity at the first place. And life with human dignity is something that the Constitution protects. So, as I was telling you, of course, the question that you've asked is probably the most important thing that one can ever ask. But there is rarely anything that is outside the ambit of Article 21. You take, for example, in the initial years when Article 21 started, flourishing because people started relying on this particular provision to accommodate their claims that could be, let's say, competing claims as well. Because today, if you say that I have a right to environment, a wholesome environment, I might say that I have a right to livelihood. So I can conduct this particular business operation here. So it can go up to that extent that they become contradictory to one another. But still, things like, let's say, at the initial years when 21 started flourishing, you see cases pertaining to custodial violence. With regard to this, I would like to also, of course, I will take it up in the course of the discussion, something called a public interest litigation mechanism that we have in India. So public interest litigation mechanism, that is again a creation of the Indian judiciary, that has to a great extent helped Article 21 grow. And not Article 21 has not grown in isolation. It has grown in light of Article 14. It has grown in light of Article 19, which collectively you call as the Golden Triangle. It has also grown in light of the directive principles. It has grown in light of the fundamental duties and the preamble to the Constitution. So Article 21 is technically everywhere. It is all pervasive. So initially, if you see the cases that were, addressed, that the concerns that were addressed by Article 21, custodial violence, right, police atrocities, right, gradually it went ahead and it proceeded towards so many different things. They had actually taken note of, we have heard about something called an epistolary jurisdiction. And what is an epistolary jurisdiction? It suggests that when you entertain letters as writ petitions, right? Letters were written to the judges of the court. If you have heard about Justice V.R. Krishna Iyer, if you have heard about Justice P.N. Bhagwati, they were the activist judges who have actually led this movement forward. And Article 21, now there's another important aspect to it. See, during emergency, we have to understand that during emergency, the image of the Supreme Court was tainted to a great extent. Why? Because it failed to give recognition to the basic rights of the people in this country. If you look at the case of ADM Jabalpur versus Shivkant Shukla, if you look at the judgment has literally failed to give recognition to the basic rights and liberties of the people. People were held and put behind the bars, and the Supreme Court could do nothing about it. But because there was a loss or erosion of popular faith in the judiciary, they picked up this mechanism of public interest litigation, and it helped the court to, again revamp its image and then stand up on its own, because it wanted to become the people's courts, right? If you read authors like Upendra Bakshi, because on public interest litigation, I think there is a huge amount of literature, and prominent among them, if you see, recently there is a work by Anuj Bhuvania, which is primarily talking about, let's say, public interest litigation. Quoting the People is the title of the book. So if you read that book, right, and several, Oxford Handbook on Indian Constitution and several books, they are flooded with writings on public interest litigation. So public interest litigation has taken you anywhere and everywhere, right? And especially when you see that the idea of locus standi has been relaxed. If I am the aggrieved party, it's not only me who can approach the court. Anybody can go there on my behalf. So public interest litigation or social action litigation, whatever you call it. So from that perspective, the court has intruded into different territories, like that of environment, like that of privacy, like that of, things like, as I said, custodial violence, reproductive rights of women, gender parity, equality, so many different things. And if you look at the different dimensions, they have come up with so many unique solutions that one can ever think of. Right? Even if you look at the Ramlila Maidan case, merely because the police had intruded into the premise at the wee hours of the night, the court came up with this idea that right to sleep peacefully is a part of Article 21 of the Constitution. You cannot enter somebody's house or premise at the wee hours of the night and start beating them and harassing them. Right? So these things, everything come along with Article 21 of the Constitution. Pavement dwellers, you deal with pavement dwellers, you deal with food shortage in the country, so many different things, so many things. So it's not the only thing that, that Article 21 has also dealt with the idea of right to die. Because right to die was, if you read the case of Gyan Kaur, or let's say, Rathinam, yes, P. Rathinam, these cases, talking about passive euthanasia, all these cases, Aruna Shanbag, these cases are all about Article 21 of the Constitution and ultimately the right to live with dignity. Because the question that arose was whether right to live with dignity includes the right to die as well. So life can entail anything and everything, right? So from that perspective, if we look at it, environment, several tanneries, MC Mehta, we all have heard about MC Mehta, I'm sure. He's one of those activists who has practically, popularized the idea of public interest litigation in particularly environmental matters. So from that perspective, if we see cases like MC Mehta, or let's say Vellore Citizens Welfare Forum, so many different cases. So everywhere, tanneries case, Ganga pollution case. So all of these have actually helped us in protecting the environment of the country. But not everything has been really good. Of course, not everything has been, very, very positive, because we have to understand that all that is being done through the process of interpretation. And the judges are not the one, or let's say they are not the only stakeholders in the process. We have we have a legislature, we have the executive. If the executive and the legislature don't function parallelly and help the judiciary in achieving these basic demands of the society, it creates a lot of problems. So Article 21 has, though the courts have been extremely activist, it has taken they have actually been very, very active in this sphere. We have seen that, let's say, if you talk about a case like Vishaka versus State of Rajasthan. Vishaka versus State of Rajasthan is one of the prominent cases where we see judiciary is engaging with international literature. It is relying on conventions on different, like Convention on Elimination of All Forms of Discrimination Against Women, ICCPR, ICESCR, and all of them. And then they are realizing that we don't have a law in place which would deal with sexual harassment of women at workplaces. So what should we do? The Supreme Court says, let us frame guidelines. But it took them so many odd years to come up with this sexual harassment law. Why is the parliament so lethargic in coming up with a law? If you talk about Sabarimala, the Sabarimala judgment says what? That women are, or they are entitled, women, even the women of menstruating age, must be admitted to the Ayappa temple. But the problem is, immediately the next day, when you're justifying things on the basis of Article 17 and untouchability, you see immediately the next day you practice a purification ceremony. So you can imagine the huge gap that is there between what the judges actually want to achieve and what is actually being achieved. The society is a problem, right? So at times, if I'm happy with the judges, I will call it judicial activism. If I'm unhappy with the judges, I will call it judicial overreach. So probably that's how it has come a long way over the years. Of course, if I pick up one single topic to discuss them, I think that will take us probably an entire day. But of course, in short, these are the specific things that Article 21 has touched upon, specifically in recent years, if you have heard about the right to privacy. So these are, privacy all along, Puttaswamy judgment, and how privacy is being dragged into everything these days. Right? If you talk about the let's say the different laws in this country, for example, gender justice, if you talk about LGBTs, right? So different aspects, everywhere you will see privacy is being dragged, because you can't do anything without privacy, right? The right to be forgotten. All these things are being brought within the ambit of Article 21, or at least they are making attempts to bring them within the ambit of Article 21. Yes.
I can spoke about society and the Sabarimala case. So I need to ask you something, that don't you feel that we are the people who create the society? Before the judgment, I think the mentality of the people who are creating the society, who are part of the society, should change first. And after that, the judgment will actually, become successful. Otherwise, what is the point of it all?
See, with respect to this, I would like to cite a very renowned jurist whose name is Ehrlich. He talked about a concept called a living law. Now, what is this living law all about? Ehrlich says that there is a law in the statute book or in the books, and there is a law that is functioning in the field, and the gap between the two is huge. Now, the ultimate purpose of anybody, may it be a legislator or it is the judiciary, whoever it may be, their ultimate objective is to bridge this gap. Because what is happening in reality, I will share an experience with you. I had this opportunity of working with the interstate migrant workmen when I was pursuing my LLM. And it was an empirical research. I had to visit the different bricklins and different places where, let's say, certain building activities were carried on. So probably I wouldn't have realized the futility of labor laws in India till the time I had visited that particular place. You would not imagine that small little children, they would, of course, the brick making process, let's say 250 rupees would be given to each family to make bricks of around, let's say, 2,000 to 2,500 bricks every day. The man would put the bricks into the... Pardon?
Ma'am, your voice and your video, it's a bit blurred and distorted. I think that's...
Okay, can you see me clearly? Can you see me clearly now?
Not yet.
Okay, just... How is it now? Not very clear. Okay, I think we should allow it to, be fine on its own. There's some problem with the internet here.
It'll be fine.
Right. So I was just talking about the interstate migrants, and of course, Article 21 is a major part of this too. And if you would visit these bricklins, or let's say these places where generally we see that people from different parts of the state, or let's say from different parts of the country, they are coming and working, you would be literally disturbed to note that rupees 250 is being paid to each family, and the entire family is working. The man is making the bricks, the woman is carrying the bricks to the furnace. House, the site, house that has been provided to them is probably around 1 feet or 1.5 feet. And when I asked the employers that what is the reason as to why they have provided these kind of houses, the answer was that the house size is immaterial. They are here to work. They will work, and at night they will crawl into the house. They will stay there. They will try to get a sleep, and from the next morning they will again start working. When I was taking the empirical research, because I was not well versed with the Odia language, my friends would translate it for me. One of the people, he was totally drunk, and he came to me and he was crying in the same, he was crying in Odia, and he said that, "Madam, every day or some or the other people, they come and they interview us, but none of them do anything for us." So you can realize the intensity of the situation, that the labor laws talk about different ideas like creche facilities, or let's say a cafeteria, or let's say good sanitation. These have been reduced to a mockery. And where is Article 21? There is no Article 21. Article 21 is dead for them. If you look at things like, let's say, the Asiad case, where the Supreme Court had intervened, the Delhi Commonwealth Games, all of that, what do you see? That the people, the migrant laborers in India, the COVID situation, the COVID pandemic is the biggest example of how Article 21 in India has been reduced to a mere mockery. We don't have anything to do here. And initially the Supreme Court was reluctant to be a part of it. But later on the Supreme Court actually had to intervene. What was the government doing back then? Why did the government not have any mechanism that would actually protect these migrant workmen? People who are wealthy enough, they have traveled back, to different countries to enjoy their vacation during COVID, to escape the COVID. But the people who are dying on the streets have not been protected. So as you are talking about the idea that we can't only blame the people, we can't blame the people, we can't blame the government. So we have to blame the entire system. The system is problematic. We have to take note of that. Everything is happening from an elitist perspective. We have to take note of it. And when we talk about constitution, we talk about ideas like we the people of India. It's not we the people of India, I believe. So I think the we part, it misses out on a number of people. The poor people, right? The LGBTQ people. When we have a tremendous, huge amount of trafficking industry, which is happening. Prostitution is not yet illegalized in India. We don't talk about them. The Supreme Court tries to argue that the LGBTQ constitute a minuscule population of the country. That is the utmost mockery of the Supreme Court. That is an exclusionary approach that you're adopting, which you're not supposed to adopt. You are the Supreme Court. You have to understand the meaning of sex in Article 15 of the Constitution. And sex is not limited to sex, the biological binary equation of a man and a woman. We have to also consider the idea of LGBTQ. So from that perspective, I think, what you're trying to point out is it very much makes sense, and I definitely agree with you on this particular point.
Thank you. So going on to the next question, which is, what's your view on marriage rape as it violates Article 21?
Could you please repeat the question?
Sure, ma'am. What's your view on marital rape as it violates Article 21?
Okay. As far as marital rape is concerned, see, in India, we see there has been, several attempts to bring marital rape within the ambit of Article 21 of the Constitution. However, there is a tendency that we have seen among the higher judiciary, or let's say the judiciary at large, where we see that they try to argue. It's not that, the judiciary is very much, let's say, they are on the same page when it comes to understanding the value of, or let's say, the idea of marital rape. If you see in the recent, I think few years back, there was this case called independent thought. In this case of independent thought, the question was whether, let's say, because if you have seen exception 2 of section 375 of the Constitution, which says that the moment a woman is married and her age is 15 years, she is, in a position to be raped. She is in a position to be tormented by her husband. That is probably what the intent of the lawmakers was. And that was based on the idea that marriage is nothing but an institution that legalizes sexual intercourse. Now, when you go back to people like Blackstone, who try to justify that merely because the husband is protecting a person or a woman, the husband has every single right to demand some kind of, sexual acts from the wife. This is basically the assumption. Now, it's not that the Supreme Court has not realized it. In independent thought, the Supreme Court read down exception 2, and they said that, see, here you are making a claim that 15 years of age is for a married woman. So above 15 years of age, the consent can be given. But the problem was that 15 years is directly in conflict with the other laws of the land. If you see POCSO, if you see, Child Marriage Act, all of them are talking about 18 years. But IPC 375 exception 2 talks about what? It says 15 years. So there is a, inconsistency in the age that is, pretty much visible. So what happened was, and interestingly, just few years before that, there was this Criminal Law Amendment Act that was brought about in the year 2013 in response to the Nirbhaya judgment. So this particular act, it made the age of consent, an ordinary age of consent, as, let's say, 18 years. But with regard to the exception 2, it made no changes. Supreme Court intervened and read down exception 2 and said that it is not 15 years, but we will consider it as, let's say, 18 years from now. So that was read down and it was considered 15 has now become 18. But the Supreme Court did not say anything about marital rape. They said that this was not the question before us, so we will not answer this particular question. Now, gradually, if you see, Justice Verma committee report, they made an assertion that marital rape should be done away with. But hilariously, if you see the Supreme Court arguing that if we declare, let's say, marital rape or exception 2 as ultra vires the constitution, it would lead to an invasion in the matrimonial domain, or it would actually amount to, disturbing this entire institution of marriage. But as far as we understand the idea of equality, I'm reminded of a judgment delivered very recently by Justice Chandrachud, probably in the case of Joseph Shine versus Union of India, where he says that gender equality is the essence of any institution, and more specifically the institution of marriage. Because you are treating two spouses as equal. And merely because the entity changes from a stranger to a husband, that doesn't give you the authority to ravish a particular woman unnecessarily against her consent. But our Supreme Court has failed to realize the problem or the fact that Indian Constitution talks about equality, not only outside but also within the spheres of the house. We need to respect that particular fact. Because it's not that the Supreme Court has not entered into the four walls of the house. If you look at the judgment delivered in the case of Air India versus Nargesh Mirza, the Supreme Court is defining the role of a woman, and it is saying that a woman has to be, this profession demands glamour. A woman should get married at this particular age. A woman should procreate children at this particular age. So you have already entered into that sphere of the family. Now, merely because you believe that, the sexual union is the core of the institution of marriage, standing here at the threshold of the 21st century when you are giving long lectures on equality and gender justice, this particular argument doesn't stand. So marital rape ought to be considered as a violative provision. It is ultra vires the constitution, definitely ultra vires the constitution. When you have done something in the case of, let's say, Joseph Shine. Joseph Shine is what? Adultery. Adultery talks about what? That with the consent of the husband, if a man wants to enter into a sexual union with a woman, he can do it. Supreme Court realized how very stupid this was. And the Supreme Court struck it down as unconstitutional. And I feel it's high time for the Supreme Court to realize how very stupid the same, and the logic is being applied to this case of Section 375, Exception 2. And the same logic is applied here, and it is done away with based on the presence of Article 14 and 21 of the Constitution. So we are talking about privacy. We are talking about things like that. Where is it? So under such circumstances, I think marital rape is something that should be taken, immediate note of. But Supreme Court is, I think even in 2019 there was a case where Supreme Court says that no, we are not going to deal with this. Why? We don't know why, but it's no. But what is apparent to us is that they want to save the institution of marriage. If you want to save the institution of marriage, then you shouldn't talk about individual dignity. Individual, you are recognizing an individual. You are forgetting that the woman is an individual, which you should take note of. Right? So I think these are, several problems that we have to take. And it's not that the Supreme Court is not an activist court when it comes to these matters. It has struck down talaqul biddat or triple talaq, instant triple talaq. It is actually entering into the four walls of the house and declaring these inconsistent practices as unconstitutional. So from that perspective, I think marital rape also doesn't stand a chance or doesn't stand the test of time, and it should be done away with at the earliest.
No, ma'am, you think marital rape is not considered as a rape at all?
It is considered as rape only if it is performed on a girl who is below the age of 18 years. For people who are above the age of 18 years, it is not considered as a rape.
And I think we're running out of time, and I wish I could ask many more questions, because I have so many questions in my mind right now. It was a wonderful session, ma'am. And before we conclude this session, I would just like to thank you for sparing your time from your busy schedule to just be here and attend this session, this webinar. It means a lot to us. And also a big thanks to Legal Law Forum for conducting this wonderful webinar with you, ma'am. And we hope to see you again very soon. Thank you, ma'am.
Thank you. Thank you so much for this opportunity and for the generous introduction and for the fantastic set of questions that you have raised. And I'm eagerly waiting to join you once again and looking forward to many more, fantastic sessions with you. Thank you. Thank you so much for having me. Thank you.